Hello. I hope we have some participants here. I'm Chris Martin. I'm a head of the Lindsay Kenney Employment and Labor Group. You've joined us for on this in this online world. We hope it runs smoothly. I've got with me Matt Stainsby and Tamara Dewar. We're going to present on vaccines, privacy rights, and developing areas of the law related to COVID that employers should know of. We think this is topical. Just by way of introduction, some of you on the line know me. I've been practicing law for 20 years, as you can see from the lack of my hair. And I've been at Lindsay Kenney the majority of that time. I'm a litigator. I practice in the employment group. I've been in all levels of court in British Columbia. I've been in front of the Employment Standards Tribunal, the British Columbia Human Rights Tribunal, both acting for employers and employees. So I'm well versed on when things go sideways, how the courts deal with these types of matters. Matt Stainsby is with us. He's been an associate at Lindsay Kenney for approximately 6 years. He's beyond hitting a golf ball farther than most people can. He's a litigator as well. He's got employment practice, and he's been before the courts and tribunals doing that. Tamara Dewar is with us. She works out of our Langley office. She's developing quite an extensive practice in employment law. She's been doing workplace investigations. She works on developing written policies and procedures for employers. She's also had the experience of working in the United States. She started her career down in California and enjoyed the realities of the LA lifestyle for so long and decided to come back home to the Greater Vancouver region. So from here, we've got, I think at the bottom of the Zoom, we're all learning how to use this. There's a Q&A button, so you can write questions in while we go along. The procedure is going to be, I'm going to have Matt talk about vaccines. I'll talk about privacy rights, and Tamara will clean up the COVID sick leave legislation at the end. We're not going to interrupt that flow. We've got some slides that will help sort of outline the discussion. But if you have a question, you can write it in the Q&A section and we'll address it at the end. Or you can wait till the end and then try to jump in on the Zoom and ask the question at the time, and one of us or all of us will try to answer it for you. So with that, we're going to lead off with Matt and his summary of this interesting topic of vaccines. We keep hearing they're coming, so let's see it.
Okay, so Chris just took you through a bit of the overview of what we're going to go through today. I'm going to start, as Chris said, with the issue of vaccinations, and in particular, whether you can implement as an employer a policy requiring your employees to vaccinate. Now, that can take a number of different forms, and I won't get into too many details, but essentially the question comes down to, well, can I say to my employees, you cannot come back to work unless you get vaccinated? Chris is going to go through a few slides on privacy rights of your employees and what information you can and can't request and what information you can and can't keep. But the vaccination issue raises an interesting point in relation to what you can actually ask your employees to tell you about their own health before you kind of step over that line. In respect of the vaccine itself, you can get a policy, or you can put a policy in place that requires your employees to be vaccinated prior to returning, but there are significant limitations to that. I don't know if anybody on this webinar is in a unionized workplace. What I'm going to talk to you about today is in relation to employees who are not unionized, because When you're dealing with a unionized workplace, you come into a lot of other issues get raised in relation to what your CBA actually says. So if you have specific questions about, hey, I've got a unionized workplace, I'd like to know more about that. Well, you'd have to kind of go back to that CBA to see, okay, what am I allowed to do, and what potentially is this union going to grieve if I try to implement something kind of off the bat. So in relation to workplace, Chris, I believe it's Chris, maybe Tamara, will be going through a bit later the requirements under the Workers' Compensation Act to keep a safe work environment for everybody. Now, vaccinations play into that pretty significantly because at this stage anyway, the transmission of COVID-19 and potentially other variants of that are extremely strong. So it is very easy for that to be transmitted, and therefore taking active steps to ensure that your employees don't get or contract COVID-19 originally and then don't pass it around if they were to come into the workplace. It's very important in ensuring that you're protecting all of those employees. The balance is really in relation to the privacy rights of your employees versus health of all your employees, and then safety of your employees in your workplace as well as your customers versus your individual autonomy of those workers. One of the things, and I won't be able to get into very specific instances, but one thing that is going to weigh pretty heavily in determining whether or not a policy requiring vaccinations is your particular workplace and what you require from your employees in relation to, for example, being at work. So if you were to, for example, run a tech company that doesn't require your employees to work in the office at all, or even prior to COVID-19 protocols being in place, didn't require your employees to be in the office, requiring a vaccination probably is not going to be looked at favorably by a court if somebody were to challenge it. The reason being is that if you're not risking employees or customers by not having vaccinated employees coming into the workplace, well, then really the requirement for a vaccination comes down to primarily your decision that you would like people to be vaccinated, and that's not really what this is about. If, on the other hand, you are, for example, running a restaurant, or if you're running a retail location where there's lots of interactions between employees and your staff, and your customers, well, then a vaccination to protect those individuals would much more likely be acceptable, or an acceptable intrusion on privacy or health rights to ensure the safety and health of everybody. So when you're deciding, do I want to put in a policy, one of the first things you want to think about is, okay, what am I trying to achieve here? And is my workplace one where a policy would be something that would help me achieve those health and safety goals? So we can just go to the next, there we go, thank you, Sita. There are some exceptions to what I said in the first slide, which was, yes, you can put together a policy. There are some exceptions to that, but that's not really an exception to having a policy. That's an exception to the policy itself for individual employees. So there are those who might say, well, on religious grounds, I don't want to get a vaccination. For some religious reason, I don't believe, or I would not allow my body to take a vaccine in any form. Now that would have to obviously be considered. There are health issues with vaccinations. There have been reports that have said, well, there are certain people who are susceptible to having adverse reactions to a vaccination, and that would have to also be part of your policy, or at least the ability to kind of review the employees when they come to you to say, look, I've got this health issue, I'd like to be exempt from this policy. And then finally, the big one here, and I'm sure people have been very cognizant of it. I know my wife tells me about it almost every day, which is the availability of a vaccine. Because if you are to implement a policy that says you can't return to work until you get a vaccine, and a vaccine is not available either to you because of your age or something else, well, you're now putting that employee in a position where they can't earn an income and can't earn a living because of a policy you have in place that they personally have no kind of bearing on how that is going to be administered to them. So until there is a policy, until there is a vaccine available to everybody, it would be very difficult, especially if somebody were to challenge it, to say, well, this policy is in place for a health reason, so I'm not going to allow you back to work, when, again, I couldn't, for example, get a vaccine until sometime in the summer. Now, the question about health and religion and potentially other grounds for protection under the Human Rights Act, that's kind of one side of the issue in terms of people who don't want to get a vaccine. Then there are those who are going to come to you and say, well, I don't want to get vaccinated. Now, if there is no basis other than simply I don't want to get vaccinated, I don't believe in vaccinations or something along those lines, that doesn't really provide them with the same protections as something like a religious belief or a health risk, in terms of not agreeing with the policy that you've decided to put in place. That doesn't mean that full stop, you can just say, well, then I'm going to terminate. There are things that you would want to look at, particularly in the context of long-term employees, where you have to make a decision, what am I going to do with this particular person who's come to me to say, I don't want to get the vaccine? Well, one thing that has been happening in the last year in many types of employment is that employees are working from home. So if, for example, that individual is already working from home or can work from home, has the ability to work from home, and that would work for your particular type of employment in your office or whatever it is that you're running, well, that might be an accommodation that you should make in the circumstances. And there may be some other ways that you can accommodate, such as off-hour schedules. For example, if that person is doing data entry, it doesn't necessarily mean that they need to be in the office from 9 to 5 when everybody else is there, that they might be able to come in from 5 till midnight or 1 o'clock, do their work then, so that they're not actually interacting with any of your employees or any of your customers. Now, again, it will really depend on the type of employment, or sort of the type of work, the type of job they're doing, because there are certain jobs and industries that you simply can't just go off hours. So if you're working in retail, well, you can't really have somebody come in at midnight unless they wanted to come in to start stocking or doing other things within that workplace that wouldn't require them to be interacting again with employees or customers. So before making a decision, it's always a good idea to look at, okay, what else can I do? Even though you may think, well, look, it's not a human rights issue, it's just a personal preference. That all might be true, but this is something that the court is going to be looking at for example, if people are getting terminated because they don't agree with the policy. These sorts of cases are going to be fairly novel. There have been some cases in the past. Most of those cases involve unionized workplaces, just because they're able to bring those claims more easily, and there's generally speaking a bigger discrepancy in terms of, okay, what can we actually do? We've got a CBA that tells us what we can and can't do, and now you're trying to implement something else for these safety reasons. In an employer context, there aren't very many of these types of cases where a policy has been implemented and then somebody decides to terminate. So while you might believe that you are in the right to terminate, and I don't necessarily disagree with you, it still might result in litigation. So you'd want to consider, are there options for our employment and this employee to make sure that we don't get involved in this type of litigation. Again, when something is new, it's difficult for you to determine, okay, what risk am I going to be taking by doing this, because you just don't really have that set of outcomes that you've seen in the past to make an informed decision. So as I said at the bottom here, you may end up determining that there's grounds to terminate if an employee refuses, but you still want to take into account some additional factors. A couple of things that you'd want to take into account. A would be your employee's history with the office, whatever workplace you're in. You know, if you've had issues with this employee in the past, if you think there may be litigation coming, well, that might be something that you want to consider in terms of, okay, what sort of steps should I be suggesting in terms of accommodation, so that I can A, say that to the court later, and B, avoid litigation if at all possible. You also want to look at the severance obligations that could happen if you were to terminate. So if you've got an employee that's been there for 25 years, the severance obligations or notice in lieu of damages in lieu of notice are going to be a lot higher than somebody who's been there for 1 or 2 years. So you want to consider that, because again, if you get involved in litigation, you want to make sure that you're setting yourself up to be protected and to ensure the lowest risk you have if that employee were to take, you know, the next step. And again, just to kind of briefly go over that, some of the factors that are going to be important, or we believe are going to be important moving forward, are: does the employee need to be in the office? And sorry, again, these are factors that are important in terms of deciding what to do with an employee who says, I'm not going to be vaccinated. Again, you look at, does the employee need to be in the office? Are there other ways to stay safe? Now, those are sorts of things you need to put in place anyway, but are they going to do a good enough job that a vaccinated employee coming into work is not going to present a huge risk to everybody else? And finally, if you're going to put a policy in place, it would be very wise to get some advice as to how to frame that and how to prepare that policy. We've got a lot of experience, and as Chris said, Tamara's got a lot of experience in terms of workplace policies and procedures to get that in place such that you aren't going to be having fights about every piece of it. And that if you have somebody that is deciding, I'm not going to be vaccinated, or they've already told you, I'm not going to get vaccinated, before taking the step of saying, well, then you're not going to come back to work, or we're going to have to let you go, talk to a lawyer, because there may be workarounds, there may be ways to address that employee's concerns, and there may be ways to get that employee into another position that, you know, A, will still be beneficial for your employer, your workplace, as well as making sure that you're not going to be up against a number of different lawsuits because you've terminated somebody and they say you terminated me only because of this vaccination issue, which you had no right to do. Again, because we haven't seen this before in a lot of cases, it's good to get some advice at the outset.
Oh, is that over to me, Matt?
Yeah, sorry, that's over to you, Chris.
So this segues nicely into Matt's touched upon it. If you're asking an employee whether they're vaccinated or not, just right off the get-go, when you're looking at this slide here, that's personal medical information. And what Matt has talked about at the beginning, and what I'll talk about a little bit for the next 10 minutes or so, is we as employers and as businesses, you're collecting this type of information inadvertently sometimes, but it becomes necessary. One, when you're enrolling employees at work, you're getting their names, their home addresses, their phone numbers. ID numbers could be their social insurance number, their driver's license number, their driving abstract, birth certificates, if there's an issue about residency, criminal records checks. Some businesses do, I know that we do. That's kind of information you accumulate at the front end to put people on payroll, put people on extended benefits. And that information has to be safeguarded in that. I'm going to move on in a second, but there's statutory limitations of what employers and businesses and organizations can do with this information they require. It's not only businesses, there's any organization, but then what flows from the information that you gather is other forms of information where you may not think this is personal, but it is, and that's sort of resumes, physical descriptions, pictures of your employees that you may want to use in a website or an advertising campaign. And then of course, medical information comes in when employees are sick or they have to go on extended health. It's a little outside the scope of this, but there isn't a right to inquire about that medical status to a certain extent. So it seems pretty straightforward, personal information, but I think we all, as an employer, don't necessarily turn our mind to the extent of personal information that we have for employees and of course customers, because they're now with everybody trying to pay online and get bills online, we're collecting information and storing information that is personal information for the customers. The big thing about this is being responsible for the information, and the responsibility comes from, I hope that all of you are aware, there's a Personal Information and Protection Act under British Columbia legislation, and that legislates what employers and organizations can do with the information and how they're supposed to store it, how they're supposed to protect it, and how they're supposed to deal with inquiries from the public or their employees about what information they have. There are a few exceptions. I don't think anybody in the call is a public operator, but you'll recall, just sort of as a topical example of how this can go sideways, is TransLink was recently hacked by a third party, and all of their employee and customer information was accessed. They fall in the Freedom of Information and Protection of Privacy Act, and they have the same responsibilities as individual employers have. So when you're reading about their problems in the class action lawsuit against them, those are any organization collecting information is exposed to that liability. There also is legislation that mirrors the provincial legislation federally, and that would be for federally regulated companies. I'm not sure if we have any of those on the call, but there's the equivalent legislation if you are one of those interprovincial companies. So broadly speaking, the issue is be accountable. You have responsibility, and you have to be aware of the responsibility of the information you collect inadvertently or expressly. I think the rule of thumb, it says the reasonable person test, and it should be this: require as little information as necessary. If you're wondering why you're asking for information from an employee or a customer, just wondering would be the alarm bell. If you don't need it, don't ask for it, because you don't have to store it and you don't have to protect it. So you should try to minimize the amount of information you're obtaining. I've touched upon about what the Act outlines, but it really will flow into what Tamara will be talking about, is you need a policy and procedure in place to deal with personal information, how you store it, how you record it, how you manage it. There has to be a person designated in your organization to be sort of the privacy commissioner or the privacy person, where any member of the public or any employee can go to that person and say, I want to know what information you have of mine, and I'd like you to provide it to me. And then they can determine whether that's information you should have or not have. So that is one of the sort of litigators always like to say, an ounce of prevention prevents a huge legal bill at the end of the day, in that if you're taking proactive steps to understand your requirements under the legislation and putting in a procedure, that helps internally to know what you're doing with the information, storing it, and how far to an extent you can use it. If we go to the next slide, I put at the beginning, it's consent. Now, consent can be implied or expressed, but it should be the hallmark of any issue. I think what I get calls about all the time is, I've got an employee using a cell phone that we've issued, and I know that they're not out in the field. They're having a nap at a local park every day between 12 and 2. And or I have an employee doing personal items or starting another business on a company computer. That's an issue that can be dealt with right at the outset of employment by saying, look, any issued computer by work, or any issue phone by work, or any device we give you, whether it be an iPad, a laptop, or the like, is work property, and there is no expectation of privacy on that. It's for business purposes. You can use it for social purposes, but don't expect your interactions in the world at large to be private. And that's the way to deal with the use of, one, to monitor the use of your organization's accessibility to the internet, in that you don't want employees posting things during their work hours or things contrary to your interests. But that goes to consent. You just make it an express term of employment contract or a handbook or the like, that there is no expectation of privacy. Regarding customers, is that you have to, I would think, in your invoices, or we do in our retainer letters, or anything in which you're seeking this information, is explaining to them that by providing that information to pay their bills, or to provide a proposal to the organization, or to seek your input or expertise, that they're consenting to the limited use of the information they're providing. And so when you're looking at policies and procedures, the best ones are the written ones, because they're in front of you. They can't, as long as you're complying with the act, they don't necessarily have to be written, but I would strongly suggest that they are. And then I've set out a number of questions that you should be turning your mind to when you're looking at the information the organization has. But as I've touched upon, it really comes down to this: proportionality. Don't seek more than you're entitled to. Seek the limited amount of personal information that you need to assist your organization or do the business that you're in. And then it's the reasonable is, are you being reasonable with that information? Are you ensuring that it's protected within the organization? And this is another problem that employers run into, not by management, not by their managers, not by anybody disclosing information. It's not turning their mind to other employees accessing each other's information. And that's one of the issues that has arisen at common law, is that employees then go onto the company computer and start going through the systems and finding personal information that another employee has entrusted with the organization, or rummaging through client files, or finding out information that they couldn't otherwise access in the public. So it's making sure not only are you safeguarding it from the outside, is that you're firewalling it in the inside of the organization to make sure there's unauthorized access. So if we go to the next slide, I've touched upon this, the potential liabilities. It's how I make a living. Without liability, or without organizations using the idea of an ounce of prevention, it ends up in my office and me telling them, okay, we can fix this, or we can't, but it's going to cost you a lot of money. So the first thing you should be aware of, a violation of PIPA, Personal Information Protection Act, can have consequences in which, if there's a complaint to the Office of the Information and Privacy Commissioner about your organization's use of that information, and they think there's reasonable grounds to investigate you, they will. Now, the consequence of that isn't draconian, but it eats up time. It causes stress within the organization. You're running around on the back foot versus being proactive about these kind of things. There is, under the Privacy Act of British Columbia, it's a tort or a cause of action to violate the privacy of another. And the key to that is that I don't have to prove damage. I give you my banking information and it inadvertently gets hacked and somebody has just my information, my home address, my credit card information, I can sue you. I don't have to prove that I've suffered a loss at all. Just your information, my information not being safeguarded by you is the cause of action. And that's why it becomes a class action, because enterprising lawyers know that, well, Chris Martin isn't going to have that much damage, but if I can tag nominal damages of $1,000 for each member in the class, well, I can make a lot of money in a hurry. And that's why TransLink's being sued. And it's less of a concern vis-a-vis smaller or mid-tier organizations with employees. You may only have 10, 20 employees. It's the customers. How many customers' information, credit card information you have, and the bigger the organization or the bigger the net, that's the bigger potential liability of these kind of claims. And then finally, it's the common law. There's a developing tort or cause of action, and that's the intrusion upon seclusion, which is really a codification or a common law acceptance of the codification of the Privacy Act. And that was a case out of Ontario that went to the Ontario Court of Appeal. But this was where two employees of a bank worked together. One of the employees' husband left her and went to the other employee, and the other employee decided to access the co-employee's information. It was about 132 times she accessed it, and by getting the banking information, she had access to basically everything they were doing, in that she had credit card statements and the like. So that's a real liability that I touched upon, is being concerned about not only how management and the organizations running or protecting themselves from these exposures, it's turning your mind to, okay, well, if I can access this, who else in the organization can? And that's really about the safeguarding procedures that are part of a comprehensive policy. So with that, I'll send it over to Tamara.
Thanks, Chris, and thank you, Matt. Yeah, no, it's important to look at the potential liabilities that you could face. And so I'm going to talk about some practical tips for employers and how to safeguard your organization to comply with the new regulations under the Employment Standards Act, and some of the new requirements and mandates from WorkSafe BC. So the first one I want to talk about is there's this new COVID-19, it's a leave of absence. There was two major changes to the Employment Act last year because of this pandemic. The first is this COVID-19 related leave. You should really be familiar with this, because I'll show you at point 3 is the tricky one when you're dealing with employees. So this amendment does provide a job protected leave for employees if you meet the 5 conditions below. Obviously, if you have an employee who has been diagnosed with COVID-19, you don't want them back in the workplace. You could face a negligence lawsuit if anyone gets infected. Second point would be employees who are in a quarantine or self-isolation, or under the guidelines of the BC Health. I think a lot of you know that there's the new travel advisory, and people have to stay in a hotel for a period of time. Again, protect the company. You don't want people coming in with COVID or having any risks because there's exposure to you as the employer. The third is the one that we're seeing a lot of, and it's tricky. So employees can take time off to take care of a child or dependent adult. They can take a COVID-19 leave. And that is a significant change in the Employment Standards Act, and you have to be aware of that a lot of people have had to take a leave because you don't have childcare. It's improved in the last little while, but you know, with the schools closed, that was very difficult. Fourth, employees directed by their employer not to return to work. And then those who are outside of the province cannot return to the province because of some of the border and other travel restrictions we have. Now, note that this COVID-19 leave is an unpaid leave of absence. So they are entitled to take a leave of absence. It's not necessarily a paid leave of absence. The second aspect is not on the slide, but one thing that I want to make sure, and I'm talking to a lot of people who I presume are employers, you want to make sure that you have a written contract, obviously, a written employment contract, but you need to make sure that you are in compliance with the new mandates and policies that are enforced. So the second sick leave provision we have is, it's called the illness and injury leave. And that's another amendment to Employment Standards Act that came in because of COVID. That provides 3 days of sick leave. We didn't have that in BC before, and so I would advise many employers to update their employment agreements in this regard. And that's 3 days annually, and it doesn't need to be related to COVID-19, but all employees are eligible after 90 days. We're going to switch to, stay on this line, please. So I want to talk a little bit more about this COVID-19 leave and what to do when we're dealing with employees that have child care responsibilities and care for sick or disabled employees, because that's going to be an issue when we come up, when there's availability of the vaccine, whether or not people are going to take it, and we can mandate that, or whether they have to disclose if they have the vaccine. So as it stands right now under this COVID-19 leave, the employees coming back from such a leave of absence are entitled to subsequent employment in the same or comparable position. So it doesn't necessarily have to be the same position, but it has to be same or comparable. So I strongly caution you, don't put them in what would be deemed an inferior position, a loss of managerial title, or loss of hours or loss of pay. You're going to be in violation of the act at that point. They're also entitled to take this leave for as long as they continue to meet the criteria, which is a hardship on employees, but it's mandated now and it's part of the law. Also, if you've got issues with high-risk employers or COVID-19 exposures, you do now have the right to refuse their return to work if there's safety concerns that they will expose the other employees to COVID. Again, there's some dispute about whether you can, take a medical note for this, but you are entitled to provide, the employee is required to provide reasonable sufficient proof that they are eligible for this leave of absence. Again, remember, this leave of absence is unpaid. I'm going to switch to the next slide. So this is a new policy that's out since the pandemic. So as we discussed, we've got the COVID-19 leave, we've got the illness or injury leave, which is new. You'll either want to make sure you have that in your written contracts or amend your employment contracts. The COVID-19 safety plan, and I know that a number of employers are abiding by it, but some are not necessarily clear what involves the safety plan. And this is a new regulation, it's mandated. So COVID-19 safety plan, you are required under occupational health safety to make sure that you ensure the health and safety of all your workers, all your employees, workers if it's union, employees if it's an employment agreement. You are also required to implement and enforce. Now, this is where some people are facing liabilities. Employees are facing liabilities. They're not enforcing the COVID plan. So you should have a written policy, your COVID-19 safety plan. You should have a person that you can report to, a designated person that can report if someone has an infection, if there's any issues about exposure. Make it as clear and easy as possible for your employees to comply with this. You also have to enforce your safety plan. So what that means is you must outline the policies and guidelines and procedures, but you have to continually assess the risk. Are your employees not doing the physical distancing? Are they failing to wear masks and then someone else gets exposed? Are you liable as an employee because you failed to enforce your COVID safety plan? Yes. Reporting procedure is key. So if you have WorkSafe BC and they're coming and doing an unexpected or let you know that there's been a report of a violation, because sometimes employees might report this, I think the key things are: 1, have the written plan; 2, have a very good reporting procedure. And it doesn't have to be detailed. In all these things, it should be clear and concise. For instance, if there's a COVID concern, talk to Chris Martin. Here's his telephone number. Here's his emails. Here's how you should be reporting. If you're not able to get a hold of him, Chris Martin's just an example, but you might have a HR person, someone in senior management. Make sure that that person can be accessible and that it's easy for them to contact, even after hours. We've had situations where, notify the person before other people are coming into work. There's also industry-specific requirements. I won't go into too much detail about that, but WorkSafe BC, I have said, has done a very good job of just outlining the different procedures that are required. And you'll see that there's new regulations, particularly in companies that have, let's say, healthcare provisions. And then here's another way to protect yourself as the employer. Matt talked about this a little bit. What if someone's not getting vaccinated? Are there alternatives? Can you reasonably accommodate? You should have a work from home policy. And then tying into what Chris said about privacy, you should outline, here's a work from home privacy policy. Here's the privacy requirements. A number of companies have monitoring now to see if, how long people are logged in, what are they doing. Useful policy to have to show that you're taking all steps to protect your employees. I also added a violence prevention policy. So you're probably asking, what is that? Well, you've probably heard on the news, sometimes there's been confrontations with customers, clients that are, anti-mask, don't want to come in with a mask. You as a company, you have to abide by the regulations. So what are you going to recommend for your employees if a dispute arises? You have to safeguard your employees as well. And what are the policies and procedures for violence prevention? Some companies have hired security guards. That's not really tenable for most people. But other people have said, like, if there's a confrontation with a client, here's the steps and here's who you should notify. Here's the steps to protect yourself and the other employees. Here's who you should contact immediately or contact the police. But consider that, because that's, if you're dealing with a company, or if you're a company that has a lot of interactions with clients and customers, you may run into the situation at some point. You want to show that you've done something to protect your employees. Can we switch just to the next slide? Okay. So a new order came in. It came in on December 16th, sorry, and it's in furtherance of this workplace safety plan, and it gave a little bit more requirements, a little bit more explanation for employees to follow. So again, as of December 16th, you're supposed to review your COVID safety plan again and make sure it complies with WorkSafe BC guidelines. You are required to do daily health checks of all your employees and employees that can work from home. If they fail to the health check or fail to abide by the health check, you can refuse entry into the workplace. A number of companies have an email. So, check off, do you have any symptoms? Have you traveled in the last 14 days? Have you had any exposure? I like the email process because then you'll always have a record of it. Some people just do a handwritten record, but documents can be lost, emails can be saved. It's much easier. It specifically says employers must prevent employees from congregating at the workplace. So this is, as of December 16th, they've mandated this. They've also required that employers must encourage and support workers to work from home when possible. So those are some of the new requirements. We're going to go to the next slide. Here's some of the exemptions for the mask requirements. This is just from the BC Human Rights Commissioner. Remember, under 12, a health condition or physical mental impairment or unable to put on or remove the mask. Matter of preference, you're not exempt. You either wear the mask and come into the workplace or the company, or you don't. And there's possibilities of fine. Here's something interesting. We'll switch to the next slide. So when we're talking about vaccinations, we'll talk about refusal work. Dr. Bonnie Henry recently said, just a couple days ago, and she said, you know, at this time, there is no mandatory immunization program in the country and in this province, and we do not expect a COVID immunization will be mandatory either. Okay, so that's a little tricky. With employers, we have this provincial health order requiring mask use. We can fall back on that. It would be so helpful if we had a provincial order mandatory vaccinations, but you know, I don't see that coming. There'll probably be some legal challenges to that. You also have to consider, you know, there's people that have that are autoimmune compromised, pregnant employees that might want to refuse it. So you have to go through the reasonable accommodation steps for the vaccination. So right now we don't have a mandatory immunization policy, and from what we're hearing from the medical professionals, maybe, maybe not. We'll see. But again, if you're complying with your COVID-19 safety plan and you're providing leave of absences as required, you're doing the company a service. You're protecting it from future litigation. There will be some situations where people refuse to come back to work. They said, "Oh, I don't want to come back to work. There's COVID risks." You know, you have to assess that and see if there's any accommodations that can be made, or if they're eligible for any COVID-19 related leaves. But if you're in a workplace that's, you know, required to have someone in the workplace, then you know, that could be what happens in those cases. And it's interesting. And this is not on the slide, but I've been dealing with these a couple times. So if they refuse to come back to work, they have a possibility under the Occupational Health and Safety Act. You as the employer must investigate to see if you have met all the COVID safety plans. And if you have, report back on the safety procedures and determine if the risk is manageable. You can have the employee, you must have the employee involved in this. If the employee still refuses to work, then you can contact WorkSafe BC and they can do a review process. And if they say you're all clear to continue work, then you can move forward and maybe make a determination of termination or layoff, but that's always tricky. But hopefully some of these practical tips you already have in place. If you don't, give Chris, Matt, or myself a call because these are mandatory requirements right now. And look, you know, you want to make sure your policies and procedures are up to date because that's going to protect you from any negligence suits that might come if someone gets infected, or if there's a litigation dispute moving forward, you want to be protected in that regards. And then another thing to think about is when it comes to these vaccinations, you know, if you are imposing a mandatory vaccinations, there's other things that you might want to talk to counsel about. For instance, would there be liability if they had an adverse reaction to the vaccine? So, but put in some of these practical tips that we've discussed now. Feel free to give us a call if you have any questions. The world has changed rather dramatically, but you know, there's the new laws out and we have to abide by them and ensure the safety of everyone and then protect the company as well.